SJC-13781, David N. Sabatini versus Kristin A. Knouse and others.
Okay, Attorney Zucker, whenever you're ready.
Good morning, Chief Justice Budd. May it please the court. This court has asked the following question: whether a claim under Chapter 214(1)(c) for sexual harassment in an educational context must be brought against educational institutions and not against individuals. The answer to the question you have posed is as straightforward, frankly, as it is important. There is no such limitation in the statute, and by the rules of construction for remedial statutes, as well established in this court, particularly in Thurndon, none should be written in. Now, a moment about the statute. It was passed in 1986 as part of an omnibus bill. You have the actual passage at the principal brief, addendum 111 and 112. And what you see in that act, first it was proposed in 81 and it was brought forward, and interestingly, sexual harassment was not defined by the SJC until 87. So you have a sense of the importance of this act in 1986. It was passed and it did a number of things. And what it did globally is important to the analysis of what happens at 214(1)(c). It added in the general laws in Section 2, it added in the workplace anti-discrimination laws a definition of sexual harassment at Section 118. And then it went on to redefine and make very specific that unlawful practices under 151B at Section 416A would include engaging in sexual harassment. It amended the Fair Practices in Education statute similarly. That is, it added a definition at 1E, and then it went on to define unlawful practices at 2G. Now, let us look at what the statute did when it came to Chapter 214, the Equity Jurisprudence Statute. There, it said very specifically, Chapter 214 of the general laws is hereby amended, adding after Section 1B, the Invasion of Privacy Statute, which we all know gets brought against individuals and institutions alike, the following, Section 1C. A person shall have the right to be free from sexual harassment as defined in Chapter 151B and 151C, as defined. It had just in the same statute, provided definitions and unlawful practices. At the bottom, the last thing it amended, it decided not to say as rendered an unlawful practice, as defined and rendered an unlawful practice in those two other statutes. And this can't be happenstance. It was in the exact same act, 1986, Chapter 588, at Addendum 111, 112. The statute is thus clear. And if one has any doubt, this court, to the extent it has addressed the issue, has addressed it by looking at the definitional section. Lowry versus Clem, cited by both sides, to be sure. Lowry versus Clem is very clear. When Lowry decides to exempt volunteers from the ambit of the workplace harassment portion of 214(1)(c), it does so by looking at the full definition of sexual harassment in a workplace context. And it decides that because the words employment and workplace are used in the definition, that volunteers are out. We ask the court simply to do the same exercise here. And what you will find is that there is no limitation written into 214(1)(c). Now, to be sure, a federal court in 2012 took up the issue sua sponte. The defendant, the individual defendant lawyer, had conceded individual liability. Nonetheless, Judge Posner decided he was going to write about it, and he did. But I ask you to look at that decision. It makes the same error, with great respect, that I think Brother Counsel makes, which is it goes immediately to the unlawful practices section and says, aha, unlawful practices are only against educational institutions, individuals are out. But the legislature decided not to do that. They determined not to do that. And under the rules of statutory interpretation, as set out so beautifully in this court's decision in Thurndon, where there is one limitation written in, we will not infer others. And where civil rights are at issue, it is not only the letter, but the spirit of the law that we shall embrace. That's Thurndon.
Well, Counsel,
Now-
can I ask you a question then about 151B?
Yes.
Okay, so in 151B, it already provides for individual liability in employment context. Right.
That has been read into the statute by looking at sections 4.4a and section 4.5. That was not actually decided by any appellate level court until the Beaupre decision in 2000. So it gives you a sense of how long it takes for some of these issues to percolate.
Sure.
But yes,
If you have individual liability under 151B,
correct.
what work does 1C do? Isn't that just duplicating what you already can do? So what's the distinct work that 1C is doing? If that,
Well, the general work of 214.1c is set out in various decisions of this court and set out in the legislative history, some formal, some informal. The formal legislative history is the act itself says it follows 1B. The informal legislative history, and I would draw this court's attention to our brief at addendum 122, 123, is a report out of the Commerce Committee. And as this court knows well, when you're looking at what a statute does that is amending prior enactments, you look at what is the mischief it is designed to cure. In this case, the Commerce
or obviate,
Pardon?
or obviate.
Yes. In this case, the Commerce Committee was clear that the mischief that it wanted to cure in creating 214.1c was the absence of sexual harassment as a form of violation of privacy. That's clear in the addendum. As for 151b, this court has determined in Thurndon and other places as well, that, and in Guzman as well, that where one falls below 6 employees, 214.1c comes in to provide the answer. Now that itself, of course, makes it clear that what we're looking at is the definition, because employers, if it was all about employers, just as it would be all about educational institutions, the definition of employer in 151b is 6 or more. So in Guzman, in Thurndon, this court has determined correctly that the 214.1c comes in to afford greater remedies and a cause of action to an individual in a workplace of fewer than 6 employees. In an educational setting, its application is even more important, and I would commend the court's attention to the fabulous amicus brief on this point more generally. But in an educational institution, this is all the more important. And frankly, on the facts of this case, it is all the more important. If you look at professors, star professors, like David Sabatini, is conceitedly and by his own description, he can move from place to place as he has done. He can sue the victim, alleged victim of his harassment. He had sex with her while she was a student registered at MIT. He continued having sex with her in a way that made her uncomfortable. When she was at the Whitehead Fellows Program. And what I would like to say to that is I expect good brother will stand up and say, well, the Fellows Programs, as in this court's decision in Nguyen, not students. That is not so on the facts of this case. The Whitehead Fellows Program is, and I would ask you to look at the briefing, the Whitehead Fellows Program is at the heart of Whitehead's educational mission. Unlike Nguyen, who is basically a part-time faculty member, they are not faculty members, they are evaluated by faculty. It's a 5-year postdoctoral training program in advance of getting a faculty position. Under 1C, it is a training program which falls well within the ambit of the definition offered at 151C1E. So the question is, do we give star professors a free pass? The answer we submit is no. We ask you to look specifically at the Haas report, which was in the motion to dismiss pleadings as well as otherwise.
Are you suggesting that there would be some difference, legal difference, or legal consequence depending on the stature of the professor? I don't really understand the implications of your pointing in particular to the fact that it was a quote-unquote star professor.
Well, the reason I am mentioning that is I think it makes it all the more important. You will see...
But why? Legally, why?
Because, and in the papers, you will see the National Academies of Sciences consensus report that was delivered in 2018. And in 2018, what we found through that consensus report, which was then adopted by NIH with further rules to follow, was that particularly in the sciences, where it is a very sort of hierarchical rule, and star professors in particular have the ability to make or break students and trainees and mentees, that their ability to silence, derail young women who are in training is significant. They tend to silence them.
That's a policy argument, right? I mean, that's great, you know, take it next door. I mean, here we're just here to address the statutory construction.
I was asked why I thought this was most important, and
I asked you
in that context.
Yeah. But in terms of the statute, yours is just a plain and ordinary meaning. The 214(1)(c) doesn't have unfair educational practices, just adopts the sexual harassment definition.
It adopted the definition, and it decided quite explicitly not to adopt the unfair practices portion of the very law that was enacted. I should say that as a matter of policy, it is clear that in Beaupre, for instance, when they found individual liability under 151B, the court went on to say, we find it for 2 reasons. One, we're looking at 4A, 4.5, and we see that there's language that could suggest individual liability. And second, the legislature has issued a broad policy command against sexual harassment in the form of 214(1)(c). And so...
Right, regardless of the stature of the professor as a star one, who can move around, whatever.
Correct.
So the legislature has defined the policy.
Correct.
Right.
Now, with respect to the federal case law that has been cited by the lower courts and cited by my brother's counsel, I ask you to look at Fournier and look at the other decisions. I think you will find that they do not contend with this as a follow-on to the right to privacy. They do not contend with the architecture of the act itself, that is, adopting the definition and not the unfair practice. And they do not contend, not remotely, with the rules of statutory construction as offered by Thurndon. Now, finally, It's also a little bit confusing at the federal court, the district court level, because, for instance, in Bradshaw, cited to say no individual liability, the Bradshaw court goes on to say, what about strict liability for the entity? And it notes that there is no strict liability afforded in 214.1c, but it decides because it does exist in 151b, it's going to read it in. In other words, there is a result-driven nature to these decisions that would counsel against reliance upon them. And there's one other federal court case that says it, I think, quite plainly, and cited by my good sister in the amicus brief, Harvey. 151c offers the relevant definition of sexual harassment, but the prohibition is in that statute. And the prohibition contains no limitation and does not seek to give professors who harass women in training a free pass. We don't think it should be written into the statute. And I will take any further questions.
Okay, I think we're all set. Thank you. Attorney Foy.
Thank you, Your Honor. I think I'd like to start, if I may, at the place where my fellow attorney left off, which is the part about whether the result-driven nature of the decisions in the federal courts. They are not so much result-driven as they are respecting the precedents that this court has enacted and has laid down for the interpretation of civil rights statutes. Chapter 151B and 151C are part of a comprehensive remedial set of statutes, and Chapter 214, it has been consistently held, is not an escape hatch from the requirements of 151B. Someone who does not comply with 151B or cannot point to a 151B provision which creates liability can't use Chapter 214 to back their way out of it.
So can I ask you to focus on the words of the statute?
Yes, Your Honor.
Why should we read into sexual harassment as defined in 151C? Why should we read into that the unfair educational practices?
Because the entire statute is what defines the unfair educational practices.
Right, yeah, so that's my point.
You don't slice
So
out.
you don't see unfair educational practices as defined in 151C. You see instead sexual harassment, which has a specific definition in 151C.
It does, Your Honor, but I think we can also agree, and I think with no fear of contradiction, that there is not a single provision of 151C which imposes liability on an individual. None whatsoever. If liability for an individual is going to be imposed at all, it's going to have to be imposed by 214C, and it's going to have to be imposed without reference to the rest of 151C. At the very same time that the
That's a
court...
problem because, just finish the thought. Why is that a problem?
Well, that's a problem because at the time the legislature enacted this particular enactment, Chapter 588 of the Acts of 1986, it was well established through Green v. Wyman Gordon, through Guzman v. Lowinger, and through other cases that this statute would be interpreted as part of that greater whole. That the notion, and I think this court and all courts have consistently rejected the notion that 214C can be read to create individual liability in a place where 151B and 151C do not.
That was the question presented in this case.
I'm sorry?
You said we've already decided that question.
Well, I think there is no case anywhere which imposes that. This would be the first.
Okay, yeah, so that's the question presented here.
So that's in effect what you're doing, whether you are looking at the broad statutory scheme, and you are saying, well, we're going to cut a hole in that, and we're going to provide special provisions with individual liability for individuals
Do you think
or
that's what-
against individuals.
I mean, that's one way of looking at work that the court needs to do. The other way is just the legislature said sexual harassment as defined in 151B and C. You look at 151B and C, and they have definitions for that term. The legislature did not say a person shall have the right to be free from unfair educational practices as defined, which is effectively how you would want the court to interpret 214.1c.
I think that is,
And I think the reason you say that is because you read 214.1c as a gap-filling measure, that 151c's remedies are only for applicants and for vocational students. And so 214.1c would allow others subjected to unfair educational practices to have remedies under 151c.
well, I think what has happened here in the jurisprudence, not so much my contentions, but in the jurisprudence, Judge Ponser, Judge Woodlock, the appeals
None of
court,
which is binding.
all of them, no, none of which is binding on you. I understood. But I think that when a series of judges reaches a uniform conclusion, I think that based on the language of the statute or their reading of the statute, I think perhaps we should ask ourselves whether the alternative reading, which seems better, why it didn't appear to any of them.
Right. And
Why
so
it
why
didn't-
is that? What was the reasoning for, you're familiar with these decisions. I've
Right.
only read Fournier. What was the rationale for reading into 214.1c unfair educational practices for the term sexual harassment? What was the rationale?
Because none of them take the position that 214C, excuse me, that 151C or that 214C was intended as a complete, independent, new basis for liability. They all look at 214C, they say this gives the Superior Court jurisdiction, and they then look at what is prohibited. In the case of 151B, they see specifically language in the statute, including language in connection with sexual harassment, which specifically imposes individual liability. The one I tabbed while my colleague was speaking was excuse me, section 16A, for an employer personally or through its agents to sexually harass any employee, personally or through its agents. That's the kind of language that's missing from 151C. That's the kind of language you don't find there. The only liability imposing provisions of 151C are contained in section 2, which specifically addresses things an educational institution may not do, and in section 3A. And I would add that the section of 151C, section 2G, that Dr. Knouse is relying on, is one that was added by that same enactment, 588.
I'm sorry, can
And
you
it
say
was
that again? I lost the.
Chapter 588 not only put in the language in 214C prohibiting sexual harassment, it also inserted language that Chapter 2 of 151C is hereby amended by adding the following subsection, that it will be an unfair practice to sexually harass students in any program or course of study in education, any educational institution. And that was specifically amended into the section which states that only institutions shall be liable.
I want to ask you,
There was ample opportunity, I'm sorry, Justice Holmes.
I want to turn your attention to a different part of Section 1C. As I understand your argument, you are in essence taking an approach that would make liability under Section 1C coterminous with liability under Chapter 151C, correct?
Not necessarily. I think that
Why? What would Section 1C reach that Chapter 151C would not?
I think that's a good question.
That's why I say
That's not something that the case is addressed.
I think that's what you're in essence arguing, though, is that we're importing all of the parameters of Chapter 151C to determine the scope of Section 1C. So that's why I use the word coterminous. If that is correct, I'd like you to turn to the last sentence of Section 1C, if you would, and explain to me what it means.
And the sentence that you're referring to, I believe, is
Says no claim under this section that is also actionable under Chapter 151B or Chapter 151C shall be brought in Superior Court, and then it says unless basically you filed with MCAD first. And it seems to me a necessary meaning of that sentence is that there are claims under Section 1C that are not also claims under Chapter 151C. And I'm having trouble giving meaning to that sentence while also accepting your argument that Section 1C imports all of the constraints of Chapter 151C. Does that make sense? I realize that was probably the least clear way to ask a question.
well,
Can you maybe address that concern I have?
I think perhaps I can. I think the analogy here obviously is to 151B, where Section 214C provides a right of action for individuals whose employer have fewer than 6 employees.
Right, but we're not,
Would otherwise be excluded entirely from the scope of 151B.
right, but here it says or 151C. It does include 151C in this sentence as well.
It does include 151C in the sentence as well. And for example, I think there are, under Section 3A, admissions to vocational schools are specifically, cannot be done on the basis of sex. I can see 214 expanding that to many other types of schools other than the vocational schools specifically referenced there.
So why can't it also expand liability to individuals?
Because I think it is such a fundamental change. I think that where a statute is written in such a way that the statute itself cannot possibly be read to impose individual liability. 151C can't be. It just can't. The individual liability is going to lie under 214, or you're not going to get it at all. And when the enactment that was also amended at the same time specifically, directly, and on its terms rejects individual liability, and the legislature leaves that in place, I think it's very difficult to assume that such a sea change in the discrimination law of the Commonwealth was intended.
But why couldn't the
By 214.
implication be the opposite, which is if the legislature thinks, well, individual liability is covered under 1C, so we don't need to worry about it under Chapter 151C?
Well, then, Your Honor, I find it very hard to see why they would have also inserted that one new liability creating provision, the one provision that was intended to enact and give force to the generalized prohibition, which is Section 2G, and put it into the section which deals with strictly liability of educational institutions. I'll add one other thing, that at the time the legislature did this, Title IX of the Civil Rights, Title IX had been enacted in 1972. Title IX does not provide for individual liability, prohibits sexual discrimination or sexual harassment in federally administered educational programs. Any college that accepts federal funds cannot practice sexual discrimination under Title IX. That does not provide for individual liability. If Judge Woodlock is right that this,
Is that expressly stated in Title IX?
I believe it is, Your Honor.
So oddly, it's not expressly stated in 214(1)(c). You would have thought that if the legislature was adopting the Title IX approach as you described it, which is expressly stated, as you say, it would have done the same in 214(1)(c).
Well,
I
I think it
understand that
is-
that's the backdrop.
Pardon me. I think it was expressly stated in the sense that it does the same thing that 151C does. It says educational institutions shall not do this. And then that's it. And 151C adopts the same approach. Educational institutions shall not do this. Certainly, I just want to point out that certainly I think Dr. Knouse, at the time she was pleading her claims, did not regard 214C as the sole basis for liability because it's captioned 214C/151C.
But that doesn't matter.
So, well, no, it doesn't, but I think that
One could easily read that as defined sexual harassment is defined in 150.
Well, I think what I'm appealing to here in part is the common understanding of the bench and the bar about the way discrimination statutes work in Massachusetts, and the fact that if we were going to find in this comprehensive statutory scheme,
You
if
can
we were
ask
going
for
to find
different-
something that changed it, we'd find it more explicitly than that.
Can I ask you just a slightly different question, Chief?
Sure.
What happens to student liability if we adopt the construction advocated not by the Educational Institute, but the others?
Well, I think if there's individual liability, then there's necessarily individual liability for everyone. I don't understand. Certainly, if you're looking for some limitation on individual liability in 214C,
I'm wondering what the practical implications are for a decision adopted.
yes, no, I think the practical application is once you open that box, all of the genies come out because the limitation on personal liability isn't found in 214C. I'm not saying it is. The limitation on personal liability is found in 151C. And if you say, well, 151C is irrelevant, it's personal liability for anyone, then I think then we're only going to rely on 214C, then you necessarily have the prospect of students suing students, teachers counterclaiming against students. I don't think there's another way to get there. And you certainly don't see it addressed in the briefing. I mean, I didn't read it in Dr. Knouse's brief. I didn't read it in the amicus brief. What is the limiting principle here?
Okay, I guess that's to be determined.
End with a question.
Thank you.